Divorce Talk Radio does not give legal advice, neither does it reflect the views of Rockford College. To obtain legal advice, you need to retain an attorney in your own jurisdiction. Good evening, folks. Welcome to Divorce Talk Radio. This is attorney Brad Tengler here in the studio with attorney Sarah Dady to talk about the connection between divorce law and immigration law. By having you give a little bit of background about yourself and then begin talking about immigration law.
Sure, Brad. I'm from Rockford originally, left for about 10 years. I practice immigration law exclusively, family-based immigration and removal defense. And our goal here at Dady & Hoffman is to keep families together where they want to live.
When you say, let's begin by two different areas that you listed for immigration law. You said removal defense, and what was the other?
Family-based immigration.
Okay. Can you briefly define family-based immigration and then removal?
Sure. An immigrant means a person who has the intent to live and work permanently in the United States. That's what immigrant means. In order to live and work permanently in the United States, there are two main ways. Either a U.S. employer has to petition for someone, or a qualifying family member has to petition for them. And that could be a U.S. citizen's spouse, parent, sibling, or a lawful permanent resident, which is someone who already has the green card. They can petition for their spouse, or children, and unmarried adult children.
You also mentioned removal proceedings. What are those?
Deportation proceedings. People who are here in violation of our immigration laws are subject to being removed from the United States. And this includes people who are here lawfully, such as green card holders, lawful permanent residents. If they have certain immigration violations, they can also be placed in removal proceedings.
One of the reasons why we're here talking this evening is the connection of immigration law and family law. Is there a significant connection?
Of course there is. Anytime you're talking about husbands and wives and kids, and especially if someone in that mix is not a U.S. citizen, immigration law applies.
When you were talking about that first category of family immigration, you're talking about the different entities that can petition. I noticed petition for status of an immigrant in the United States. I noticed one of those was a spouse can do that.
That is correct, Brad.
And reading between the lines, if they lose on their petition, then we have a broken family, correct?
That is correct.
What is involved in that process for folks petitioning for someone to have legal status here in the United States?
That is a complicated question, and we could spend the whole next hour just on that alone. But I'll try to be brief. If the non-U.S. citizen, which is referred to as an alien by our Immigration Nationality Act, if the alien spouse has never been to the United States, there's a two-step process to immigrate them here lawfully. The U.S. citizen spouse or lawful permanent resident spouse has to file a petition proving that the petitioner is a U.S. citizen or lawful permanent resident and that they are truly married to the alien spouse. Once the petition is approved, then they have to actually file a visa application for their alien spouse, and there will be an interview at the U.S. consulate in the alien spouse's home country. At that interview, they are checked for previous immigration violations in the United States, any criminal issues, and also, most importantly, when it comes to divorce, whether or not the alien spouse is going to arrive in the United States as a public charge.
So these are all petitions that spouses file when their husband or wife is still out of the country. Is that right?
That is correct.
Go ahead. Sorry.
When the alien spouse is inside of the United States, they could be here in a variety of legal statuses or no status. People can get married in the United States regardless of their legal status. So someone could be here on a student visa, they fall in love, they get married to a U.S. citizen, then they can apply for the green card, permanent residency. someone could be here after entering without inspection, which means they are unlawfully present in the United States, but they can still get married to a U.S. citizen or a lawful permanent resident. Those cases are much more complicated. There are many more immigration violations that are present, and depending on exactly what those violations are, it doesn't matter who they're married to, they may never be able to obtain an immigrant visa.
Part of this petition for, sorry, this is a bad question. I noticed spouses, and you said U.S. employers can also petition for this as well?
U.S. employers can petition for alien employees if they receive a certification from the Department of Labor that there is no U.S. citizen or lawful permanent resident willing and qualified to do the job that they need filled. You see a lot of these types of petitions in highly skilled areas like engineering and science.
How long does it take for these petitions to proceed through the process?
Family-based petitions, if you are a U.S. citizen spouse petitioning for a spouse, there are unlimited visa numbers available. So the average processing time from the time they file the petition until the immigrant visa interview abroad can be about a year, and that's fast.
What's slow?
If you are a lawful permanent resident, a green card holder petitioning for your wife, and your wife lives in Mexico, you have about 3 years to wait before a visa number is even available, before she can even have her interview.
Wow. So we have this first availability as that you've indicated for immigration attorneys to help U.S. citizens basically bring families together.
Yes.
And, you know, being a family divorce attorney myself.
So what do we do when marriage goes wrong?
Yeah, exactly.
Well, marriages, many of them do not, in fact, last forever. And that can be very...
How true.
Good for you, Brad. And unfortunately, if a marriage between two people goes badly and one of them is not a United States citizen, there are immigration consequences.
So if you're in the midst of the process of petitioning for your spouse to come to the United States and obtain legal status, and you go through a divorce in the midst of that, what happens?
The petition's automatically terminated. And it doesn't matter if you already have young children together, perhaps children that were born in the United States. The alien spouse is out in the cold at that point.
What if it happens at the very end of the process?
Well, then that depends on if the couple were married for more than 2 years or not at the time the green card was issued. If they were married for less than 2 years, then that spouse is what we call a conditional resident.
Do you see people staying in marriages because of this specific issue?
I do not, but I certainly see a lot of people who are fearful of the consequences when they separate and initiate divorce proceedings from a U.S. citizen spouse. And the answer to that is that no one has to stay in a marriage where they're unhappy just because their U.S. citizen spouse petitioned for them. That is not a requirement under immigration law, and there are exceptions for that. No one has to stay in an unhappy marriage for legal status.
Sure. It just is a more difficult process, correct, if you're not married to a U.S. citizen, or you're married but you're going through a divorce.
It's a more complicated process, but not impossible.
One of the things as a family law attorney that I am concerned about and that I see and deal a lot with is domestic violence. How does domestic violence, if at all, play a role in immigration law?
People who are trapped in abusive marriages, if they lack legal status, the abuser often uses that lack of status to control them.
Can you give an example?
Sure. If you don't do this for me, I'm not going to file a petition for you. If you leave the house and don't tell me where you're going, I'm going to call immigration on you.
But isn't that not a vain threat? Because based on what you just described about these family petitions for status here in the United States, they can do that, right?
Well,
I'm going to divorce you unless you let me continue to abuse you or not complain to the police.
or if you divorce me, I'm going to get you deported, and you're never going to see your kids again. That's the most common thing. If you call the police on me, they're going to pick you up and deport you, and you're never going to see the kids again. That is a very common threat that I hear in abusive marriages where one spouse is not a U.S. citizen. And it's not a idle threat on the face of it because, you know, we've deported nearly 2 million people from the United States in the last 5.5 years. The deportation rate of this country is horrifying. We've deported over 200,000 parents of United States citizen children in the last couple of years. But on the other hand, we do have some protections built into immigration law specifically for victims of domestic violence.
What are some of those protections?
Under the Violence Against Women Act, which is up for reauthorization before Congress as we record this, it allows the victims who are married to U.S. citizens or permanent residents to petition for themselves for permanent residency without being dependent on their abusive spouse. And the process is also confidential. So the abusive spouse is not involved at all.
So, wife files this petition saying that I'm being abused. Husband is completely unaware of it, correct?
Correct.
How does the court system, the administrative system, make a determination of whether she's telling the truth or lying? When people lie about this?
You would think so, but no. Most people don't lie about being a victim of domestic violence. First of all, it's been in my experience that it's shameful. People are ashamed that they've gotten themselves into a relationship where they've been treated so badly and controlled. Secondly, the standard for proving abuse is by any credible evidence. So if the police were called, if a police report was made, if they sought counseling, if they left and went to a domestic violence shelter, statements from family and friends who witnessed the abuse or the effect of the abuse, there has to be evidence. You just can't walk into a USCIS office and say, I'm a victim, and you get a green card. There is a process.
So an abused wife files this petition to obtain status, and it's under the Violence Against Women Act. After she files the petition, then what's the process?
Well, remember, this also applies to children as well.
Okay.
In many families, we have a spouse who's an alien, and then we have children who were aliens, who were born outside of the United States. Children who are abused can also self-petition under the Violence Against Women Act.
When you say self-petition, I'm thinking of a 6-year-old petitioning. Obviously, it's not the 6-year-old. It's someone that's standing in their shoes.
No, it's the 6-year-old.
Explain.
Minor children, when it comes to immigration, if a 6-year-old child is an alien and has been the victim of abuse and their citizen or permanent resident parent will not petition for them, if someone stands in for them, such as they've been placed into foster care due to the abuse,
okay. Sure.
Then certainly they will hopefully make a connection with an immigration lawyer who will file a petition for them for legal status.
Do you work with DCFS with these kinds of issues at all?
Interestingly, DCFS has investigative powers into abuse situations, which means in certain cases, DCFS could actually certify that a minor is a victim of abuse, and even if that minor's abuser was not related to them as a parent who had legal status, that minor could apply for legal status under a special visa called a U visa, the letter U. Unfortunately, in the state of Illinois, DCFS has declined to date to certify for U visas for minor children who have been abused who lack legal status.
Why is that? That doesn't make sense.
Because they don't want the extra paperwork.
What is involved in the process of certifying?
Writing down the victim's name, date of birth, dates of abuse, brief description, and then signing it.
And you attach that to your petition for status.
Correct.
That's unfortunate.
Yeah, there's no good reason for DCFS not to want to do all that they can to protect minor children, particularly children who are not U.S. citizens, because lack of status is easily exploited. And these children are victims twice over because of their lack of status.
So let me just take a step back so I can understand the process a little bit in terms of filing a wife who's being abused. She files a petition. After she files this petition, what happens then? What's the next step?
Well,
Is there a hearing on the evidence? How does that work?
it's filing a petition, and that's filed with U.S. Citizenship and Immigration Service,
Okay.
which has a specialized unit who has received specific training in domestic violence.
And is that an administrative agency or a court?
It's an administrative agency.
Okay.
It's under the Department of Homeland Security.
Okay.
Once the petition is filed, if they feel they have enough information to make a decision, they will, and it can take up to 12 to 13 months.
And when you say if they feel they have enough information, simply by reading the petition and any attached affidavits?
What's included with the filing is you have to have proof of the marriage, proof of the spouse's legal status, which can often be very difficult for victims to obtain.
Do you need proof of legal status of the spouse of the abused, even if they're being abused?
Yes.
So your husband, if he's abusing you, has to be a U.S. citizen?
Or a lawful permanent resident.
Okay. All right.
So the type of evidence that's normally collected, if there was a jointly filed tax return or an individually filed tax return, and that has the citizen's spouse's Social Security number on
Sure.
it, copy of birth certificate, copy of a green card, any identifying information that would lead one to believe that this spouse is a U.S. citizen or permanent resident. And USCIS is fairly flexible on the evidence because they understand that a lot of victims are literally fleeing in the middle of the night out of the house with the clothes on their back. And because of the circumstances of the abuse, they don't have access to a lot of documents, official documents like this. So the other thing that will be included will be the victim's statement describing the abuse in the marriage, witness statements if there are any.
Is it a sworn statement?
It doesn't have to be, but it has to be signed and dated by the applicant, the self-petitioner. Proof of marriage, if they have children in common, the children's birth certificates, proof that they live together in the same house, proof that they suffered abuse, and proof that the self-petitioner is a person of good moral character. Because if they themselves have certain criminal convictions, they're not eligible for an immigrant visa.
And so the initial determination about whether abuse is occurring is based simply on the petition and the attached statements and documents that are attached to that.
Correct.
There's no hearing. There's no personal testifying of the alleged victim.
That is correct.
Okay.
And that's important because once the petition is approved, if it is approved, and if USCIS wants more information, they'll send a request for more evidence if they feel that there isn't enough there. Once the petition's approved, many times the self-petitioner can immediately apply for a green card, and then there is an interview with USCIS.
Do you ever see clients who have obtained, say, orders of protection from their U.S. citizen spouse and then bring those to you, and then they apply for citizenship based on the basis of that and use that as evidence?
Absolutely. Orders for protection are very good evidence of abuse because there's already been a hearing before a state court judge
Right.
who issued the order.
I'm fascinated with how evidence is weighed by these administrative agencies. Because one of my questions is how do they make a determination of lying? And if there has been an order of protection, there's been a full hearing, then that certainly is evidence. In fact, conclusive in the sense that a judge has made a decision that there's been abuse.
Well, the way it for self-petitions under VAWA by any credible evidence. So statements can suffice, and then any supporting evidence. It's a good standard for victims of domestic violence because, as I said, many of them don't have access to the family's income tax returns, to the family's bank accounts. The abusive spouse controls all of that, and they don't have access to it.
So the administrative agency makes an initial determination that the petitioner is abused based on...
Has been a victim of domestic violence by a U.S. citizen or permanent resident spouse.
Okay. And then what is the next step after that?
They apply for permanent residency.
And is that a separate petition?
Yes, that is a separate application, and that will result in an interview before USCIS. And we have a field office in Chicago and one in Milwaukee for Wisconsin residents, and the applicant will have to appear for an interview.
During that interview, are they asked questions about the abuse, or that's already been determined?
That's already been adjudicated.
Okay.
Their VAWA self-petition has been approved, so there should be no re-victimizing of the victim at an adjustment interview for permanent residency.
What are the kinds of questions that are asked during a permanent residency interview?
These are in the statute. Here are some samples. Have you ever been convicted of a crime or offense in the United States? Have you ever committed a crime or offense for which you were not arrested? Have you ever been affiliated with the Communist Party? Have you ever been affiliated with the Nazi government of Germany? Have you ever been involved with a terrorist organization? Have you ever received weapons training? Ever been involved with a group that buys, sells, or provides weapons to any other group?
So the petitioner is honest and says, yeah, when I was 18, I smoked pot all the time and was never convicted. What happens?
Well, if they admit to a crime that they were not convicted of, but they admit to it, they can be found inadmissible and their application denied and then placed in removal proceedings.
Even for something like a misdemeanor that is nonviolent?
Absolutely. Our immigration law is quite harsh. I don't think most Americans understand how rigorous the standards are that make it, oftentimes impossible for people to obtain legal status. Here's a good example. There are many people here lawfully who are authorized to work here who do not yet have a green card. And they can go down to the DMV and get a driver's license. Sometimes when they go to get a driver's license, a couple weeks later, they get a notice in the mail that they are right now registered to vote and told where their polling place is. Well, they never intended to register to vote, but they signed the registration form when they renewed their driver's license. Unfortunately, under immigration law, falsely claiming to be a United States citizen is a ground of permanent inadmissibility, which means they can never ever get a green card. Registering to vote is a false claim to citizenship. It's very tricky. And in many cases, our immigration system just sets people up to fail. Seldomly is there ever a do-over in immigration law.
I want to go back to pot smoking. You used the word...
I
have no idea why.
Brad.
You use the word may be denied for any crime, including nonviolent misdemeanors. So on what basis do they make that determination? Because it sounds, from what they're saying, they don't have to deny.
One of the grounds of inadmissibility is anyone who has committed a controlled substance offense. Okay? Any controlled substance offense is inadmissible to the United States. There's one exception. For people who have been convicted of possession of 30 grams or less of marijuana, they can obtain a waiver. So that's why I said
a waiver of what?
Inadmissibility.
How do they obtain a waiver of inadmissibility?
Well, they have to pay a filing fee and apply for it and show that there's more good than bad about them and that they've been rehabilitated.
I.e. that they're not they're no longer committing these nonviolent misdemeanors, i.e. possessing.
Well, and keep in mind that this pertains to one conviction for possession of less than 30 grams of marijuana. One.
So if it's two.
And the other part of that, it really depends on if they have a lawyer or not. Because number one, an immigration attorney is going to prepare them for the interview, so they know what the questions are going to be. Two, if a USCIS adjudicator wants someone to make a confession and admit to a crime for which they had never been arrested, that adjudicator has to follow certain procedures. If there's an attorney present in the room, we're going to make sure that those procedures are followed before they could result in a denial.
So someone could be denied, basically, going back to the Violence Against Women Act. They could be denied permanent residency, even if they are being abused, but had committed a nonviolent crime.
That is
for
correct.
which they've not been convicted.
Yes. Here's another example of a crime that will result in a denial of permanent residency. A felony conviction for theft. That is considered a crime involving moral turpitude under immigration law. It does not fall within a petty offense exception because it's a felony, and that makes them permanently inadmissible. Well, sometimes there are waivers, there are exceptions, but usually it's going to result in a finding of inadmissibility.
I want to go back to basically the practical implications for families of a wife who has been abused by her American citizen or husband.
And remember, this applies to alien men as well. It could be a male spouse. The Violence Against Women Act applies to any alien spouse, regardless of gender.
So if a husband is being beaten up by his wife, then he can also apply.
You know, I've seen plenty of abusive marriages with
Sure.
U.S. citizen wives being abusive to their alien spouse.
Sure. So in both of these situations, after they apply for permanent residency, and they're denied based on the factors that you indicated, then what happens to them?
They can be referred for removal proceedings.
And you say can be, meaning sometimes they're not?
Yes. The Department of Homeland Security only has enough resources to place 400,000 people per year in removal proceedings, which is an administrative process. It's held before an administrative court under the Department of Justice. 400,000 people a year is the maximum ICE has the resources for. We have over 11 million undocumented people in this country. On top of them, we have millions more who are here lawfully, but also have certain immigration violations that subject them to removal. And we simply don't have the resources to put everyone in removal proceedings at one time. It would take over 30 years to put everyone in removal proceedings. Therefore, ICE has to prioritize, and they have. The people that they place high priority on for removal are people who've been deported before, people who have been convicted of drug trafficking offenses, serious drug offenses, violent crimes, and then not violent crimes, and then property crimes, and then minor crimes. That is supposed to be their priority list. From what I've seen, they've pretty much been sticking to it. So if you have someone who's denied an adjustment and they have a minor criminal record or no criminal record, they may not be referred for removal proceedings at this time, just due to lack of resources by the Department of Homeland Security.
Sure. Going back again to the
Pot smoking?
No. You answered all my questions about that, and I very well. I have a great sense of relief. With the Violence Against Women Act, so another question. We have an abused wife who files. During the midst of the process of filing, her husband, for whatever reason, catches wind of this. In addition to beating her again, he then files for divorce. So then she's filing for legal status, but her husband is filing for divorce, and soon she won't have a husband who is a U.S. citizen or has legal status himself. What happens?
That is a great question. Luckily, VAWA, the Violence Against Women Act, addresses that. VAWA applicants have up until 2 years after divorce is final to apply for protection under the Violence Against Women Act.
Okay.
So divorce is not a problem. The biggest problem is that most victims don't know about VAWA, and many times their divorce attorneys don't know about VAWA.
I had no idea about this law.
So it's critically important that any divorce attorney find out what their client's legal status is. And if they have no status or they're a conditional resident, they should definitely consult with an immigration attorney.
Sure. You mentioned anything else about the Violence Against Women Act that you think is important?
I think this is really important. Depending on the case, if an abused spouse files under VAWA, they could be able to get work authorization within 90 days of filing, which means then they can get a Social Security number, a driver's license, they can apply for a job and start to support themselves and start that road to independence. So it can be very...
Which is absolutely essential in domestic violence cases.
I
see that time and time again in divorce cases where there's abuse going on. Like you said, you have one of the spouses, and I've been saying women, obviously it's men too, but my experience has been I've usually observed women in these situations, but they don't have any financial means because their husband is controlling everything. So in this particular case, they're able to work.
Yes, pending the adjudication of their petitions. And it's very empowering, and it's very important because most women, or victims of domestic violence who don't have legal status, they will stay in the marriage because the abusive spouse supports them and the kids.
Sure.
And if they leave, they don't know where they're going to go, they don't know how they're going to support themselves or the children. So the Violence Against Women Act is a really wonderful option for a lot of people.
U visas, you mentioned them briefly. What are they, and how do they relate to families?
The U visa are for certain victims of certain qualifying crimes, such as domestic violence. Congress passed the U visa primarily as a tool for law enforcement to encourage immigrant victims to report crimes committed against them. Many immigrants fear the police, especially in this climate of deportations. Many immigrants don't see a difference between local law enforcement and immigration and customs enforcement officers.
Is that due to a lack of education, or is that because practically there's a connection?
No, I would say that I don't blame them, especially when places like our local county jail here cooperate with ICE, and when non-U.S. citizens are booked in, they're more than happy to turn them over to immigration and customs enforcement. So ICE has vans going down to our local jail 2-3 times a week to process people for removal proceedings. So, I don't blame them for confusing local law enforcement with immigration and customs enforcement. But that's detrimental to our community because our local police don't have the authority to enforce immigration laws because immigration laws are civil laws, not criminal. And we need to build trust between our vulnerable communities and local law enforcement. If we want to have a safer community, we have to have that trust. The U visa is an excellent tool for law enforcement to encourage that trust.
How so?
In order to apply for a U visa, a victim has to cooperate with the investigation or prosecution of the crime committed against them. In the case of domestic violence, as we just saw recently in the Rockford Register-Star, very difficult cases to prosecute because oftentimes victims don't want to cooperate because the abuser is their sole means of financial support, because the abuser exercises so much control over them. They're afraid. If they do cooperate with law enforcement, then law enforcement can sign the certification form that they were a victim, they cooperated, and then they can apply for a U visa. If the U visa is approved, then they're in lawful status for up to 4 years. After they have it for 3 years, they can apply for the green card, and they're fully authorized to work.
So what does it mean to cooperate with local law enforcement?
That's entirely at the discretion of local law enforcement.
Meaning what?
Meaning police chiefs can sign youth certifications, state's attorneys can sign the youth certifications, and they can decide what certifications they're going to sign and under what circumstances. So it's very subjective. But in the case of domestic violence, this U visa is a good possibility if you have a couple and neither one has legal status, or they have children together and they're not married, and the victim doesn't have legal status, and they're not legally married, so VAWA doesn't work there. A U visa may. So long as they report the crime, cooperate with the police in giving a statement, if they're asked to testify against the abuser, they don't unreasonably refuse to, they could apply for a U visa if local law enforcement is willing to sign the certification.
Here in Rockford, when is local law enforcement willing to sign?
Well, here in Rockford, the state's attorney's office signs most of the certifications. They do a pretty good job, but there's some things with that are particular to victims of domestic violence that I think local law enforcement needs some more training on understanding.
Like what?
Like understanding that a victim of domestic violence is very fearful of losing their main source of support, especially if they don't have legal status. I think that it would be really good if our police officers were trained on U visas so they could explain them when they encounter a victim who seems very fearful and reluctant to cooperate, so they could understand something good can come out of something bad. An abusive relationship is bad. A U visa, legal status is good. And it should be used in that manner, which is the way Congress intended. It's not a reward for being a victim. It's to help build trust between immigrant populations and local law enforcement to make our communities stronger. But it only works if our local law enforcement knows about it and uses it.
A question about the effect of immigration laws on, say, custody. Any insights into that as an immigration attorney?
Sure. A parent's legal status is completely irrelevant to their fitness as a parent. And so legal status or lack thereof is an inappropriate factor in determining child custody. But oftentimes you will see in contentious divorces the citizen with legal status asserting that the parent without it shouldn't have custody because they can't get a job and they're illegal and they're going to be deported. That should always be a warning sign.
Isn't that something, though, that a judge would take into consideration under a best interest status if, say, someone could be deported?
Well, here's
and they
the
have custody?
thing. Here's the thing about that. As we've discussed with family-based immigration, it's that U.S. citizen spouse who had the power to file the petition. So if the alien spouse doesn't have legal status, the first person you have to look at is the spouse with legal status.
And you're saying in terms of who should be at fault for that lack of legal status.
What I'm saying is they can't use that against the spouse without legal status since they were responsible for filing that petition.
Have you dealt with cases? Have you been involved? I know you don't do custody cases, Sarah, but have you been brought in for consultation purposes or work closely with the divorce attorney in a custody battle involving this issue?
Usually when it's involving domestic violence, yes. And I have counseled clients about their rights and their ability to obtain legal status and protect themselves and their children during a custody fight, sometimes in the context of divorce, sometimes not. I've seen plenty of clients who were never legally married to the father of their children or the mother of their children, and there's a custody issue, but usually it comes into play with domestic violence issues.
We've talked about U visas. We've talked about the Violation Against Women's Act. We've talked about the basic petitions for obtaining legal status, and we talked about custody and its connection with legal status as well as immigration issues. Any other area, anything that we have missed? I know we haven't gone into fine details with a lot of these things. I think you said prior to the interview you could talk for an entire segment on each one of these issues, but any other major category that you think is important?
Well, I think that we could touch briefly on the affidavit of support. We mentioned it early on, but the affidavit of support is really important for people to understand.
What is that connected to? What petition or what proceeding?
The family-based petitions.
Okay.
If a family member petitions for a spouse, they have to sign an affidavit of support, which is a contract with the federal government that states until their spouse or immigrating family member either becomes a United States citizen or leaves the United States permanently, regardless of divorce, Brad, regardless, this contract continues even if the couple divorce. And if that immigrant spouse applies for cash public benefits, the federal government can seek reimbursement from the petitioning spouse.
If they sign this affidavit.
They have to sign it because you can't immigrate without an affidavit of support in family-based cases.
Okay. And what does the affidavit of support say? What is and for our audience, an affidavit is a document that does what?
Where you swear under oath that you're going to perform some duty.
Under penalty of perjury.
Yes. Yes.
And in this particular case, the duty is to do what?
To support your immigrating family member up to 125% of the federal poverty guidelines for your household size. So if it's a household size of 2, that's about $18,000 a year. And even if they divorce, that affidavit of support remains enforceable against the petitioning spouse. So if the immigrant spouse ends up applying for cash benefits, like food stamps, the federal government can seek reimbursement from the petitioning spouse, even if they've been divorced for 20 years.
Well, thank you, Sarah, for your time this evening. I really appreciate it, and I'm sure people who are listening that want to learn about immigration law and its connection with family law are appreciative as well. Where is your office located?
2222 East State Street in Rockford, Illinois.
Which is just a little east of right downtown.
We're on the corner of Rockford Avenue and East State, about 6 blocks east of Swedish American.
And if people want to call your office to find the best immigration attorney in Illinois, what's your phone number?
Well, that would be Dadian Hoffman at 815-394-1359.
Well, thanks again, Sarah. I appreciate talking to you.
Thank you, Brad.
You just heard a phenomenal episode of Divorce Talk Radio. Listen to Divorce Talk Radio live on RockfordCollegeRadio.com, Tuesday evenings at 8 p.m. To hear more of Divorce Talk Radio shows, please visit RockfordCollegeRadio.com. To learn more information about attorney Brad Tengler, please visit TenglerLaw.com.